Hi, I'm Mark Schroeder from GSHC Surrogacy Agency, and today we're speaking with Eric Stovall, a surrogacy and adoption attorney in Nevada. How are you doing today, Eric?
Doing very good. Thank you, Mark.
In the state of Nevada, do the intended parents or the surrogate, do they have to be married in order to start a surrogacy journey?
Nevada law is very unique in that it does not require or specify whether any of the parties should be married or must be married. It takes the parties as they find them. So if the intended parents aren't married to each other, that's fine. If the surrogate isn't married, that's fine too. Nevada law also allows for same-sex couples without any discrimination, with either from the intended parent's side or from the carrier side. Just doesn't matter in Nevada.
If a same-sex couple are the intended parents of a child, whose name would go on that birth certificate in the state of Nevada?
Well, Mark, in Nevada, for a same-sex couple to be on both parents to be on the birth certificate, we go through a process called a pre-birth order or a parentage petition. And through that parentage petition, we can have both same-sex parents' names placed on the birth certificate as parent of the child. And that's not a problem under Nevada law at all.
What were to happen if an intended parent's or a surrogate's marital status were to change at some point during the surrogacy journey?
Well, Mark, if there is a change of marital status for either party, we can generally deal with it through a contract addendum. Obviously, if a change of marital circumstance is, if someone's going through a divorce, that's a problem for those people going through it, but it's not necessarily a problem for the surrogacy journey that's already been started. If we have a contract in place, we should be able to manage without any problem.
Eric, a common question or concern for intended parents who are just starting to research surrogacy is, can a surrogate decide to suddenly keep the baby?
Mark, obviously people will do what they want to do and what they feel like doing at the time, but legally, the surrogate in Nevada cannot just decide she's going to keep the baby. And there's several things that are behind this. First off, if we're doing a surrogacy the way the law intends, we're not dealing with the surrogate's own baby. It's not her egg that was fertilized, and it's not her baby that she's carrying. Surrogates that I speak with are very much aware that they're carrying someone else's baby. They don't want to keep the baby. Most of them have babies of their own. Well, all of them will have babies of their own, and they don't want another one. They just want to help someone through the journey. So the idea that a surrogate is all of a sudden just going to, oh, I want to keep this baby, it makes for good TV movies, but it's really not real life. It just doesn't come into play that I've seen. In Nevada, I've not heard of any contested case where a surrogate has tried to keep the intended parent's baby. That just has not happened to my mind in Nevada. Another part of that, though, is a good vetting process by making sure that the carrier has gone through a criminal background check and a psychological evaluation to make sure that she understands that process and is able to do so psychologically is an important thing for the intended parents to make sure has occurred. Again, an agency will make sure that psych profile is completed and that there's no problems, there's no potential red flags in a carrier. And if you're doing all of those things, in Nevada, it's very unlikely that anything like this would happen.
And Eric, once the birth certificate is issued, whose names will go on that certificate?
The birth certificate itself, the application for that is usually done at the hospital by the hospital social workers. And they're going to follow our pre-birth order that we've already obtained from the court that we've given to the intended parents and also to the carrier so that they can show the hospital that, and that will guide whose names are placed on the application for the birth certificate. So specifically, if the pre-birth order says both intended parents' names are to be placed on the birth certificate, their names will be placed on the birth certificate. The order would also state that the carrier and her spouse names are not to be placed on the birth certificate, and obviously their names would not be put on the birth certificate through that application process. So in essence, whatever is on the pre-birth order or the post-birth order is going to control whose names are placed on the vital records. And again, it does not matter if it's a same-sex couple or a single parent. It's not going to make any difference under Nevada law.
This has been a conversation with Eric Stovall, a surrogacy and adoption attorney in Nevada. Thank you so much for your time, Eric. Really appreciate it.
Certainly, Mark. It was a pleasure talking with you and answering your questions. I look forward to, if there's any unanswered questions, be sure to contact my office. I'm happy to answer.